Hi, my name is Carl Birkhead. I'm a family attorney with Worth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for about 8 years now, and I want to help you make law easy by talking about the changes in the statutes regarding fitness for child custody, visitation, and guardianship. So the statute we're talking about is Title 43, Oklahoma Statute 112.5, specifically subparagraphs C and D. So what 112.5 has done now is it's taken the best interest standard um, for years, and I mean years, since well before I even uh, considered which law school I was going to go to. The standard was what's in the best interest of the child. And that's what the court would look at. And it's such a broad standard that anything could go into it. Obviously, factors like domestic violence, those are big factors in that, but they weren't the be all end all in these situations. And they're not necessarily now, but they're given more weight and they're given more attention and focus than they were in the past. In the past, you're just looking at best interest. So it's as if you're trying to build a Lego set, and sure, some pieces are domestic violence, and that's part of the case that you're trying to build as to why it's in the child's best interest to be with you versus the other side. But that didn't change the shape of the case where it does now. And in some very rare cases, I'm not trying to say this was every time, but there have been cases in the past where someone has been found to be an abuser or evidence of abuse has taken place and was still able to get unrestricted, unsupervised access to the children for a number of factors, which are really case specific. That's the difference between then and now. Now the burden has shifted. Now the statute has made it to where if you are I'm trying to think of the specifics. If you are found to be perpetrating abuse, coercive control, stalking, harassment towards the children or towards the other parent in these situations, if you are expressing this type of abusive behavior, it creates a rebuttable presumption that you're unfit to have custody or guardianship or even unsupervised visitation of these children. It's a massive change in how the law is going to be interpreted and how these custody cases are going to move forward. So if you're in these situations and you've got some of this evidence that you is maybe against you or maybe that you have against the other parent, it's absolutely going to be incredibly crucial to the outcome of your custody case, of your visitation case, of your guardianship case. 112.5 has absolutely changed, and I want to talk with you more about it. My name is Carl Birkhead. I'm with Worth Law Office, and I want to help you make law easy. Thank you.